Good morning. As you can see, I'm holding something that says, "Caution, handle with care, I'm hot." Can you guess where this came from? Well, yes, it did. It came from McDonald's. It's a coffee cup, and I'm drinking hot coffee this morning. So, what does that have to do with my lecture? Well, I am going to talk about torts today. Torts are important to businesses because torts can be expensive area for businesses. So a tort is a wrong and it causes civil liability. It's different from contracts. And there are several things that we're going to discuss today about torts. But one of the most famous cases, of course, is the McDonald's hot coffee case, which is somewhat of a misunderstood case. Basically, a woman named Stella Liebeck was buying coffee and at McDonald's, and she wasn't driving or anything. She was in the passenger seat of her grandson's car. She was 79 years old. She ordered coffee in a styrofoam cup at the drive-through window back in 1992. After getting the order, the grandson pulled his car forward and he stopped so that she could add cream and sugar to her coffee. She did place the cup between her knees, attempted to remove the plastic lid from the cup, and as she removed the lid, the entire contents of the cup spilled into her lap. She had extreme burns from this and basically had to spend a lot of time in the hospital, went through skin grafting and other terrible, painful procedures, and she sought to settle her claim for $20,000, but McDonald's refused to do that. Well, during discovery, McDonald's produced documents showing more than 700 claims by people burned by its coffee between 1982 and 1992. And these are severe burns. If you ever look, you can look on the internet and see the burns that Ms. Liebeck suffered. McDonald's basically held its coffee at between 180 and 190 degrees Fahrenheit, which is, to me, delicious coffee when it's that hot. However, that's close to boiling. And most other establishments were selling their coffee at much lower temperatures, like 135 to 140 degrees. Well, Ms. Liebeck sued, and she was awarded $200,000 in compensatory damages, which was reduced to $160,000 because the jury found her 20% at fault. The jury also awarded her $2.7 million in punitive damages, which equals about 2 days of McDonald's coffee sales. Post-verdict, basically, McDonald's, at least where she was, dropped their temperature of their coffee. Subsequently, the trial court reduced the punitive award to $480,000 because, punitive damages normally should be about 3 times the compensatory damages. And no one will really know the ending because this could have been appealed some more, but the parties eventually entered into a secret settlement. So that's just one example of many tort cases that you could talk about. And so let's talk about some of our learning objectives and then get into this chapter. First of all, we're going to talk about the 3 main types of torts. And, talk about the different responsibilities there. We're also going to talk about the elements of negligence and relate those elements to the development of negligence law. And we're going to analyze the damages awarded in tort litigation. And there is some controversy about that. When I mentioned to some professors in my department, hey, I'm going to talk about the McDonald's hot coffee case, they got very aggravated about that case, and they felt that Ms. Liebeck was wrong. Other people have made documentaries and have talked about Ms. Liebeck, and actually some people feel that she's a hero. So there's 2 sides to this, and it can be controversial. All right, a tort is a civil wrong, but something other than a breach of contract. And the basis for the wrongdoing is both common law and legislation. It's an obligation imposed by that. So torts set limits on how people can act and use their resources so they don't violate the rights of others. And typically there's going to be damages involved, money damages. compensation for the loss. So you're liable for someone else's injury when you have a duty to that person and you've caused that injury. Now, there are 3 categories of torts: intentional, negligence, and strict liability. Intentional torts are deliberate actions that cause injury. So if I walk up to you and hit you over the head with my book, if I've caused injury, then I may have done what's called an intentional tort. Negligent torts involve injury following a failure to use reasonable care. So if I injure your foot because I am walking negligently past you, maybe looking at my cell phone, that might be a negligent tort. I didn't mean to do it. It wasn't a deliberate action, but it was something that caused you an injury because I wasn't using reasonable care walking down the hall or in the classroom. Strict liability torts impose legal responsibility for injury even when a liable party neither intentionally nor negligently caused the injury. So maybe, they produce a dangerous product, for example, and there may be some strict liability there. All right, intentional torts. Intent means a desire to bring about certain results and basically, when I hit you over the head with my book, I may not have intended to injure you, but if I knew that that injury is substantially likely to result from me hitting you over the head with a book, then that might be enough to be an intentional tort. Now, there's assault and battery. Assault includes the expectation that you're about to be injured. So if you see me coming toward you, about to hit you on the head with my book, that is the assault part. The battery is the actual touching without your consent. Sometimes you can just have an assault. Maybe I threaten you with my book, and you expect an injury. That would be the assault. But maybe I don't hit you. Then there's no battery. Or I may come up behind you and hit you over the head with my book. In that case, there's no assault, but there's a battery. So assault is placing of another in immediate anxiety for his or her physical safety, and battery is the illegal touching of another. Other intentional torts: infliction of mental distress, battery to the emotions, essentially. This would be outrageous conduct that has a chance of causing mental distress in the victim. Now, note the word outrageous. It has to be outrageous. You can't just have reasonable conduct that might cause mental distress. So outrageous conduct has to be present. Invasion of privacy is another one. And that is an invasion of someone's personal space, personal private matters, or one of the most common areas in business would be using a person's name or likeness for personal gain. If I take your photo and I use it in an advertisement for a product I've made without your permission, then I may have engaged in the intentional tort of invasion of privacy, and then you could sue me for damages or for an injunction to stop me from using your image, or both. Another one is false imprisonment. This comes up a lot with things like shoplifters. Now, if someone is a shoplifter, you may want to detain them, and usually there are laws that may say you can detain them in a reasonable manner for a reasonable time. However, suppose you catch somebody that you think was a shoplifter, and maybe they aren't. Maybe they're trying to show you their receipt, or maybe you take that shoplifter and you lock them in a closet for 12 hours and just leave them there. That would be the type of thing that would be false imprisonment. Another example might be an employee of yours that you think is stealing from the cash register. Maybe a 16-year-old employee who works at your grocery store. You think they stole a $20 bill out of the cash register. So you take them as their boss back into your office, and you lock them in, and you refuse to let them go until they admit what they've done or what you think they've done. And you won't let the person make phone calls, and you keep them there unreasonably for an unreasonable time. That type of thing can subject you to a lawsuit for damages. There's also malicious prosecution. If you don't have proper grounds, then you should not cause someone to be arrested criminally. This could happen, for example, again, shoplifter. If you have a shoplifter who is trying to explain to you, I have a receipt, but you don't listen. Maybe your boss has told you, I'm going to, reward you for catching lots of shoplifters this month, and you don't listen, and you cause that person to be arrested criminally. Well, that person can then sue you for malicious prosecution and sue your employer. And there are cases there that for hundreds of thousands of dollars, because someone who's prosecuted or arrested criminally without proper grounds and is later acquitted of the crime, in the meantime, their reputation's been damaged. They've been through something very stressful. They may have lost their job over it, and some malicious prosecution, tort case could be there. So that's why a lot of people who are in retail store business may give the shoplifter the benefit of the doubt because it's not worth the risk of being sued later by the shoplifter or alleged shoplifter for an intentional tort. Trespass is entering someone's land without consent or staying there after being asked to leave. Conversion is basically depriving owners of their lawful right to exclude others from some resources. For example, if I steal your book, or if I take possession of your book without your permission and keep it until after the final exam is over and then try to give it back. Those types of things could be conversion. I've wrongfully exercised control over a resource that belongs to you. Sort of like stealing, basically. Defamation is publication of untrue statements about someone else that hold up that individual's reputation to ridicule. Now, there's slander, which is oral or verbal defamation. There's libel, written defamation, or that published over radio or television. So keep in mind that the statements have to be untrue. If they're true, then it's not defamation. Also keep in mind that this type of standard is fine, but if you're a public figure, it's a little harder to prove defamation. If you are, say, Brad Pitt, and the National Enquirer believes they're printing a true story about you, but in reality it's not, you may not have a defamation case, because Brad Pitt, if he's a public figure, has to prove not just that it's untrue, but also that the National Enquirer had actual malice or hatred, which is a little bit harder to prove, evil intent. And so public figures have a little harder time with defamation cases than the average person like myself would have. Also, keep in mind it does have to be published or told to third parties. So if I say something untrue to you about you, like I say to you, you cheated on exam 2. Well, even if that's untrue, it's not defamation unless I say it to someone other than you, okay? Now, there are some privileges or some privileged communications that would not be defamation. For example, a debate in Congress or a statement by a judge in a courtroom. Those types of people have some privileges there. All right. Also, there is fraud, which is intentional misrepresentation of a material fact that is relied upon someone to his injury. Usually, it would be a loss of money. So, business fraud, for example, intentional misrepresentation of financial status or misrepresentation of property or a product you're selling. Those types of things could be fraud, which is a tort. It may also be a crime, but we're not talking criminal law in this chapter. We're talking about torts, which are person suing person. And some torts are crimes as well, but we're focusing on the tort side. There's interference with business relations. Again, we're still in intentional torts. Something like an injurious falsehood or product disparagement. Publication of untrue statements that disparage the business owner's product or quality. If I publish an untrue statement about my competitor that says, hey, that car dealer who is my competitor sells cars with, faulty engines. And if that's untrue, then the competitor could sue me for injurious falsehood. Also, intentional interference with contractual relations is a serious tort. If I start raiding another company and taking employees that have an employment agreement with that company, then that could subject me to be a defendant in a lawsuit for intentional interference with the contractual relations of my competitor with the competitor's employees. Also, if I interfere with contract or merger of one company with another, that could be a problem. Now, certainly, if employees are employees at will with no employment contract, yes, you can hire those employees away from your competitors. We're talking about when there's a contract here. That's when this would come into play. You can't induce those employees to breach their contract with their current employer without a possible lawsuit on your hands for a tort. All right, those are some good examples of intentional torts, and in a different video, I will talk a bit about negligence. Thank you.